There can be a really big difference in cost between an uncontested divorce and a contested divorce. In an uncontested divorce, you typically have already come to an agreement with your spouse on how you're going to divide your assets, your liabilities, and what you're going to do with the kids. When you've done that, really your costs are involved is in the filing and creating your final documents that the judge will sign off on to document your agreement. You may also end up with a mediation to formalize those agreements, but that's a pretty short process and, in the big scheme of things, relatively inexpensive. If you have a contested divorce, your timeline extends dramatically. You likely are going to be spending at least 5 to 6 months, maybe up to a year, in litigating your Texas divorce. So that time factor in and of itself increases the cost. It's more time that you have to spend with your attorneys, providing documents, meeting deadlines, asking for information about the assets and liabilities if you don't have access to that. So every bit of time costs more money, and you may have to hire experts in a contested divorce. You may go to mediation more than once to address things at the beginning, to address how they're going to go during the process of the divorce, and then you'll have a final mediation. So the longer your divorce takes, the more contested it is, the more it's going to cost. In an uncontested divorce, you're typically going to spend somewhere between $3,000 to $5,000, depending on how much of your agreement you have locked down with your spouse, whether there's any last-minute negotiations that need to happen, whether you need to go to mediation to document that agreement so that the court will accept what you want to do. Those things, there's some play in there, and you may spend anywhere from $3,000 to $5,000 if it's truly uncontested. With a contested divorce, you're likely going to spend somewhere between $10,000 and $20,000 to finalize your divorce. Again, every case is different, and it depends a lot on how much information you have access to, whether you have to request financial information from your spouse, whether they give it willingly or whether you have to fight for it, whether you have to have multiple hearings and or mediations. There's a lot of different factors. With an uncontested divorce, you could be done in as few as 2 months. The minimum time to get divorced in Texas is 60 days. So if you've got everything locked down and you've got an attorney who will get it all together and get it filed and ask the judge to sign off on it on day 61, you could be done that quickly. I would say typically an uncontested divorce is still going to take about 3 months. A contested divorce, on the other hand, is often at least 6 months and closer to 9 or 10 months. Usually in Texas, your divorce is not going to take more than a year. There's requirements that the courts want to get cases wrapped up within a certain period of time, and unless there's some extraneous reason why your case can't be finished in a year, it usually is going to be finished in a year. When you go to mediation in your Texas divorce, you're going to pay a mediator, a third-party person, to be the go-between between you and your spouse to help you reach a resolution of your disagreements. That third party is going to help you negotiate and help you give and take so that you come to a resolution. You're going to pay that third party their costs for being present at the mediation. And depending on the type of mediation you have and how long the mediation takes, and also how experienced the mediator is, you can pay a variety of different costs. Sometimes you may already have an agreement pretty well locked down, and you're doing what we like to call a drive-by mediation. We are going to the mediator just to sign off and bless on the agreement that you've already reached. In those situations, you may spend $200 to $300 to the mediator to get that signed off on. Typically, for a half-day mediation, 4 hours, each side is going to spend somewhere between $400 to $600 to the mediator. For an all-day mediation, it may be closer to $800 to $1,200 for that time period, because That mediator is there to help you resolve your case, and they get paid for their time in participating. Other factors that affect how much you're going to pay your mediator include how experienced that mediator is. A lot of people like to use former judges as mediators because that, in some cases, helps the process, helps both parties understand what might happen in a courtroom if a former judge is saying, hey, this is what I would have done in my courtroom. That can sometimes help the negotiations. And because of the extra experience they have, you will pay more for a former Texas judge to be your mediator. Typically, when you hire a lawyer for a divorce, they're going to ask you for a retainer. And that retainer is a deposit, an amount of money that the attorney puts in their trust account, and it's your money until they bill against it. So as they are doing work, they record their time, their staff records their time, and they issue you a bill. And once that bill is issued, then they then deduct from your retainer, your deposit, to pay the legal fees. Over time, your retainer can get depleted. As you're spending money on legal fees, you may spend more than what the amount of the retainer was in the first place. So a lot of times your lawyer is going to ask you to replenish your retainer and add more money depending on how much more they think the case is going to cost, how much more time it's going to take. You may end up replenishing more than once. Most attorneys will bill by the hour, and that is something you want to talk to any attorney that you're interviewing to hire. You want to find out what their billable rate is. And that billable rate can vary based on the amount of time that attorney has been out of law school, their experience, how many cases they've handled. There's a variety of factors that go into determining that billable rate, but they'll tell you what their billable rate is, and then that's going to be multiplied by the hours they spend on your case. In a case where you have hired an attorney that has a good team behind them, they may have legal assistants and paralegals, those support staff will be billed out at a lesser rate than the attorney. The attorney has specialized knowledge, has specialized training, specialized experience, and you pay more for that person's expertise in representing you and taking you to court to go in front of a judge. Not everybody can go into a courtroom. You have to have a law license. You have to have gone to law school. You have to have passed the bar exam. And so because of those requirements, the attorneys charge more for their time and expertise. So one of the things to ask any attorney you're considering hiring is in what time increments that they bill. Some attorneys will bill in a tenth of an hour, and that's a 0.1 for every 6 minutes. Some attorneys will round that up and bill in quarter of an hour increments. So every time you call, they're charging you for a 15-minute period or a 0.25. That can increase your bill substantially because every email that you send that attorney reads and responds to, it may not take them 15 minutes, but you are paying for 15 minutes every time that you reach out to that lawyer. So if you're considering a do-it-yourself divorce, there are options for doing that in Texas. There are forms that the Texas Supreme Court has issued that you can use. They are fill-in-the-blank forms, and you can fill that out and file it with the court. You'll pay a filing fee, and if your spouse is assisting you, you may not have to have them served. They can just file an answer or a waiver, and that doesn't cost them anything. And then you just file your final decree once you've agreed on everything. So it can be less costly from that standpoint that you're only paying the filing fees and possibly a service fee to get divorced if you do it yourself. On the other hand, the risk of missing something or screwing it up could be very costly to you. I've seen cases where people completely forgot certain assets. They didn't divide a house properly, or they didn't award the house properly to the person who intended to keep the house. And If you've forgotten something, you may be able to go back and fix that. But if you didn't know what you were entitled to and you thought the other person was entitled to keep all of their retirement and you didn't get any of it, you would be missing out because that's not true. You want to make sure that you understand what you're entitled to and have the expertise of a lawyer that can help you know what you're entitled to so that you're not leaving money on the table, you're not leaving rights concerning your children on the table. You don't know what you don't know, and you could lose out on a lot if you do it yourself. So we've talked a lot about costs and the risks of do-it-yourself divorce. If you have any questions about any of this, please give us a call at DeFord Law Firm.